Oh, yeah.
the weights. I'm like, that's not good.
How's your hand?
It's bruised.
Hey, Tiffany, we can hear you.
Thank you.
Good morning. It's 9 o'clock. It is the 26th of March. We're here for our regularly scheduled first hearing by affidavit docket of the month, which was moved from early April to late March. With me today, we have two technical examiners, Mr. Dean McClure and Mr. Andy Fordyce. The first case, though, or the second case, is Mr. Garcia's case. So we'll get to that in a minute. Let's first call Oxy USA. This is a very old case. It's almost 3 years old. It is 23679. Entries, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Oxy USA.
Good morning, Ms. Vance.
Good morning.
Ms. Vance, do you expect Mr. Bruce to join us?
I don't know. So, but I haven't heard anything from him, so I think we can probably proceed if you're good with that. Good, okay.
I'll give him one more moment.
Sure.
Mr. Bruce, are you with us? Are you representing Mewborn? Let me take a look at something, Ms. Vance, because I want to see if he filed a withdrawal of entry.
I think he filed a withdrawal of the objection, but they maintained their entry.
They did. Okay, so you know that. All right.
Yeah.
Well, he's not here. We'll have to proceed without him. I want to start with your supplemental exhibit packet. So this is a 14-page docket that you filed on the 19th of March. Is that correct?
Correct.
All right, excellent. If you'll take a look at it with me, starting on page number 3, supplemental exhibit G.
Okay.
I don't know who drafted this.
That's my fault. I should have put it in the cover pleading. I'm happy to include that. And we do have the witness here today, Mr. Stephen Janacek, who put this together. So
Can we call Mr. Janacek?
Yes, he is right there. He's got his camera on.
All right. Good morning, Mr. Janacek.
Good morning, Mr. Examiner.
Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, I do.
Would you spell your name?
My name is spelled Stephen, Stephen, Janacek, Janacek.
Okay. And what is your role at Oxy?
I am a petroleum engineer.
Okay. And have you been admitted as an expert before this division?
Yes.
In what field?
Petroleum engineering.
Okay, sounds good. So, Mr. Janacek, are you able to look at the supplemental exhibit G?
Yes, I am.
All right. What part of this, because there's exhibits that seem to go along with, that's right, Ms. Vance, there's exhibits that go along with supplemental exhibit G. Are those yours also, Mr. Janacek?
Yes, so I believe the mix-up might be that this was submitted as Exhibit G, but in the draft statement and attachments, everything is referred to as Exhibit A. I believe that might be the mix-up here.
I see. Okay.
That's
I see the highlighted. Yeah, okay, Ms. Vance, I get it. I see the highlighted parts that say see Exhibit A, page 1. All right, so then I'm going to talk about this broadly as Exhibit G. Did you prepare this entire document?
Yes, I did.
All right, so what specifically did you prepare? Let's hear it on the record.
I put together the statement and the findings. I also put together all of the sundry documents found from the OCD well files, and that also included, when necessary, the plug and abandonment final wellbore diagrams. All of that information was put together here in Exhibit G, incorrectly referred to as Exhibit A.
Okay, and how many pages is the exhibit itself?
I believe 3 through 4. 13.
Okay, so 13?
Starting on page 3, there's 1, 2, 3, 12. Excuse me.
Well, perfect. That's what I count to. Okay, Mr. Janchik, in the future, this won't be accepted as evidence. This should have been presented with a self-affirmed statement to explain to the division, first of all, your qualifications, second of all, what you did to produce this, and that it's truthful. Okay? But because you're here now with us, I'm willing to go through this extra step with you so that we can take this into evidence for Ms. Vance so she doesn't have to yet continue the case again. So did you prepare all 12 pages yourself? I didn't hear you.
Yes.
Okay. And are they true and accurate to the best of your knowledge?
Yes.
Okay. I am also concerned about a sentence in your overall, preliminary findings. The last sentence in that section. Would you read it out?
Starting with instead.
Yes, that's correct.
Okay. Instead, applicant requests a continuance so the parties can further confer with the division, evaluate the findings, and return with a more complete record after additional review.
All right. All right, thank you. And what's the basis for that argument?
The basis of the proposal there was so the division and Oxy could review the data in this hearing, and then after reviewing and discussing the data requested by the OCD at a follow-up hearing, we would potentially determine the path forward for this project.
When you say this project, do you mean the whole project or part of the project?
The whole project.
Okay. All right. So, Ms. Vance, is this typically the way you continue a case?
No, but I would like to give a little bit of color on this. One, just going back to the filing, and
Yeah.
I will take the fault on that because
Okay.
typically when we've done supplementals for, this kind of request, we've just submitted the information. And I understand now, if you look in this case, I think there was even a similar kind of filing of a supplemental. And I just followed that same kind of filing status quo. So I apologize for not including the self-affirmed statement for Mr. Janacek. That being said, the division has asked Oxy to come here today based off of some further review, looking at the application, and hopefully getting to a place where we get an order. But there were some additional requests for further analysis, particularly related to some vertical wells within the area of review and the P&A conducted on those wells. And so, Mr. Janacek has put together that analysis, but because we were asked to come to hearing to discuss that, we're not sure if there is going to be a need for us to come back. So we understand that we may actually have to file a continuance, but because this is a little bit of a fluid discussion to review the information, understand what the division's position is, and how we can move forward, we have included this language in case we do need to come back possibly in May after what we present here today.
All right. Thank you, Ms. Vance. Thank you, Mr. Janacek. So Mr. McClure, do you have any questions for this witness?
I have no questions, Mr. Hearing Examiner.
All right, we'll take this case under advisement. Thank you, Ms. Vance.
Thank you.
All right, we're off the record. Yes, Ms. Vance?
Okay,
Okay.
Thank you.
Yes. Okay, we're off the record in that case. Let's move on to Flat Creek Resources, 25255.
Good morning, Sharon Shaheen on behalf of Flat Creek Resources.
Good morning. Ms. Shaheen, we've received the additional exhibits. They've been reviewed. They are admitted into evidence at this time. Is there anything that you want to say before we take the case under advisement?
No, I would just say that if you have any further questions, all three witnesses are here today.
Appreciated. I don't believe we do. So thank you very much.
Thank you.
We're off the record in that case. Let's go to Spur Energy Partners, 25854.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Spur Energy Partners.
Good morning, Ms. McLean.
Good morning,
Oh.
Mr. Examiner.
Miss Hardy,
hear
I'm
me?
sorry.
Thank you.
I said Ms. McLean, I meant Ms. Hardy. Yes, Ms. Kessler, I see you. Thank you.
Good morning, Mr. Examiner. Jordan Kessler, monitoring on behalf of EOG Resources.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of Marathon Oil Permian, and we're just monitoring. Thank you.
Thank you, Ms. Hatley. We have one more.
There should be an appearance for Hillcorp.
Yeah. That'd be maybe Mr. Suazo?
Yes.
Mr. Suazo, you there? Did Mr. Suazo object, Ms. Hardy?
They had objected, but they then withdrew their objection.
All right. Is there any reason we can't proceed without Mr. Suazo?
I don't think so.
Go right ahead.
Thank you. Spur seeks an order pooling uncommitted interest in the Yeso Formation underlying a 320-acre standard horizontal overlapping spacing unit comprised of the north half of Section 35, Township 17 South, Range 28 East in Eddy County, and will dedicate the unit to the Cecilia 35 State Com wells. Our exhibits include the land testimony and exhibits of Colleen Bradley, who has previously testified before the division as an expert in land matters. And we have also provided the geology testimony and exhibits of Matthew Van Wee, who has similarly previously testified before the division and has been recognized as an expert in geology. Our notice information is included in Exhibit C. We did timely send notice to all interested parties on December 18th, 2025, and also timely published. So unless there are questions, I would ask that the case be taken under advisement and that the exhibits be admitted.
The exhibits are admitted and the case is taken under advisement. Thank you, Ms. Hardy.
Thank you.
Moving on to Matador Production, there are 4 cases joined, 25905, 0607, and 08.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Hat Mesa.
Good morning, Ms. Starnes.
And good morning, Mr. Hearing Examiner Yaditza Pena with Hardy McLean on behalf of Marathon Oil Permian, and we are just monitoring.
Good morning, Ms. Pena. Thank you. Go right ahead.
Good morning, Mr. Examiner. This is Jordan Kessler. I'm just noticing that Jordan Kessler with EOG. I'm just noticing that I may have put in the incorrect case numbers for my entry of appearance on different Teddy Glosser cases, which I will correct following this hearing. We're not objecting, just monitoring. So
Okay, so you're
I'd
entering
like
an
to verbally
appearance.
enter my-
Okay, very good. You're entering an appearance in all 4 cases?
That's correct.
Very good. For monitoring only. And Freya, would you, Ms. Kessler, do you happen to know what cases your entry might have put so we can clean up and remove that document from the other cases?
It looks like 25999 and 998. But let me work through some emails and I'll send
right.
Freya and copy you an email clarifying.
I appreciate it. Thank you, Ms. Kessler. Go right ahead, Ms. Starnes.
Okay, in these 4 consolidated cases, Matador seeks an order approving the standard overlapping spacing unit and pooling all of the uncommitted interest in the Bone Spring and Wolf Camp formations, underlying the east half of sections 29 and 32 and the northeast quarter of irregular section 5 in Township 21 South, range 33 East, and initially seeks to dedicate these to the Toddy Glosser State Com 113, 114, 203, and 204 wells. In support of these applications, we have timely filed hearing packets that each include the compulsory pooling application checklist, applications, the self-affirmed statements of the landman, Clay Wooten, the self-affirmed statements of the geologist, Liz Olson, and the self-affirmed statements of notice, which reflects that notice was timely sent on January 16th, 2026, as well as the notices of publication. And if there are no questions, we ask that all of the exhibits be admitted into the record and that the cases be taken under advisement.
Thank you, Ms. Starnes. So in the future, Ms. Starnes, the other information that I'd like to know before we wrap up that part of it is that your witnesses have been admitted as experts by this division. Otherwise, I need to qualify them if we're going to question them. And you said that your notice was timely mailed and published?
Yes, and both
right.
of these witnesses have previously testified before.
Well, testified as experts in their
As
fields?
experts in their field in front of the
All right.
division. Yes, sir.
Thank you, Ms. Starnes. Okay, your exhibits are admitted in all 4 cases, and all 4 cases are taken under advisement. Thank you very much.
Thank you.
We're off the record there. Let's go to Occidental Permian. It looks like we have 2 cases, 25933 and 34.
Good morning, Mr. Hearing Examiner, Mr. McClure, Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Occidental Permian Limited Partnership. And I don't believe that there are any other parties in this case.
Go right ahead, Ms. Vance.
Yeah. So in these 2 cases, Oxy seeks to pool the same acreage in both of the cases. It's just one is related to an upper Wolfcamp pool and the other is for a lower Wolfcamp pool. And that acreage is the west half of sections 20 and 29. Township 23 South, Range 32 East, and that's in Lee County, New Mexico. I do want to just add a little bit of color to this. So we originally filed this as just a single case for the Wolfcamp, and later were advised by the division that there was actually an upper and lower pool, Wolfcamp pool. And so what we did was I filed an amended application under the existing application, and then filed and that was for the upper Wolfcamp pool, and then a additional application for the lower Wolfcamp pool. I included in the hearing packet both the original application and the new amended application, and then the new application for each case respectively, because I did realize that in my amended application and new application that I had upper and lower Bone Spring, but the correct pool. And so I just wanted to be clear that, the parties just received that follow-up application that goes into the specific pools that Oxy was advised that they were in. So in case number 25933, the initial well there, or initial wells there, are the Mercury 29_20 Federal Com, 31H, 32H, and 33H, and that's an oil pool. And so the proximity well in that case is the 32H. And then in case number 25994, the initial wells are the Mercury 29_20 Federal Com, 41H, 42H, and 44H, and that is a gas pool. So our landman has previously testified before the division, and her credentials have been accepted as a matter of record. Our geologist has not, so we have included her resume. She is available and ready to be admitted as an expert. I will pause there, and I'm happy to, I know she's on here, and I'll just ask that she turn on her camera.
Okay.
And her name is Catherine Velasquez. Sorry.
Good morning, Ms. Velasquez. Would you raise your right hand, please?
Good morning.
Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Great. Would you put your hand down and spell your name?
Catherine, Kathryn, Velasquez, Velasquez.
And what field of expertise are you seeking to be admitted?
Geology.
Petroleum geology or just general geology?
Petroleum geology.
Okay, fine. What education do you have that goes to that field?
I received my Bachelor's of Science in Geology from the University of Texas at Austin and my Master of Science from the University of Vermont in Burlington, Vermont.
And do you have dates that you achieve those?
Yes, May 2012 for my bachelor's and December 2014 for my master's.
Okay, and what work experience do you have that goes toward that expertise?
Sure. I have been working as a petroleum geologist since 2015 for Anadarko Petroleum and Occidental Petroleum, working in the Delaware Basin specifically on and off for the last 10 years.
What is your current title?
Senior staff geologist.
Okay, and what are your responsibilities?
So anything from subsurface characterization, mapping, creating cross sections, reservoir modeling, and planning and drilling wells.
Okay, thank you, Ms. Velasquez. You're recognized as an expert in petroleum geology. Now, Ms. Vance, have we admitted your exhibits yet?
No, I was just getting there, but I would love to do that.
Great.
So just to put a cap on it, we have included the statements, all the required sub-exhibits, and then our notice was timely, both the letter and the notice of publication. So I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement.
Admitted without exception. Mr. McClure, questions?
Mr. Hearing Examiner, I don't have questions, but I do have guidance for Ms. Vance.
No questions. Okay, go right ahead.
Ms. Vance, earlier I think you kind of called it out. So I think you see where I'm referring to within your application, like carried through to the trio of notices, your public, written, and the divisions notice. You call out the Bone Spring Formation in both of these cases instead of the Wolf Camp Formation.
Right, with the specific pool though, so I think my brain was, I've done a bunch of NSPs with multiple pools and they're all Bone Spring, so I got my wires crossed there, but yeah, I wanted to provide some color. I did catch that, so I appreciate the feedback.
Yeah, but unfortunately, the formation is a part of our legal description, which we want to be very specific that it is correct. So we're going to need to conduct all those notices again with the proper formation included.
Well, I'd like to give a little bit of pushback for two reasons. One, under the New Mexico Oil and Gas Act, the way that pooling is done is by pool. And so we've actually included the specific pool. We don't pool by formation. So we've called out the specific pool here. The other part of that too is we've got one party that we're pooling, Coterra, and they're well aware of these applications. They've had extensive ongoing communications with Oxy. We provided that in our chronology of contacts. And we also do have our landman, Miss Mullen, who is available for question. But I mean, you know, you've got a general description of the formation, and then you've got the specific interval that we're pooling, which is identified by the pool. And you know, typically when you're talking about general and specific, you look to the specific language of what is being called out.
I was going to say, I don't know the exact way that statute is drafted, but I do know that the Part 4 in the administrative code specifically calls out formation. I guess, do you have any thoughts in regards to that?
I'd love to take a moment, you know, and be called back, but I can pull
Perfect.
up
That's
the
what we'll do.
language if that would
That's
be
what we'll do,
okay.
Ms. Vance.
Thank you.
We'll recall these two cases for the end of the docket, giving you
Perfect.
plenty of time to.
Kind of like just an inside joke.
We're going to give you plenty of time to do your research and make a legal argument based on your research, okay?
Perfect. Thank you. Appreciate it.
And are you aware of the citation that Mr. McClure has directed you to?
I am.
All right. Okay, very good. All right. Thank you, Ms. Vance. We're going to be off the record for these two cases. We'll recall them at the end. And Freya, don't let me forget to recall them. I'm going to circle them, but you never know. Thank you, Ms. Velasquez. All right. Let's move on to Marathon Oil. Looks like we have two cases, 25947 and 49.
Good morning again, Mr. Hearing Examiner and Mr. McClure, Paul Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Marathon Oil Company. And again, I don't believe that we have any parties in this case, so I would love to proceed.
Go right ahead.
Thank you. So in these cases, Marathon is seeking to pool additional parties as well as drop certain wells from the initial order. And so we have included just as a part of our hearing packet, we included the application as well as the original order, the extension order, and then a copy of an updated pooling CPAC that reflects the certain wells that Marathon is requesting to drop from the pooling. In case number 25947, Marathon is dropping the 502H, and then in case number 25948, Marathon is dropping the 801H and 802H. We have included a self-affirmed statement from our landman, Shelley Klingler, who has previously testified before the division, and her credentials have been accepted as a matter of record. And then we've included a land tract map, updated pooling, sample well proposal, and AFEs, and a chronology of contacts with those new parties. I have included a self-affirm statement of notice, and I will note that one of my notice is not timely. That was the March 17th notice. So I would beg to be able to come back to one of the special dockets in April to perfect that notice. Because Marathon is getting ready to drill these wells. They've got a schedule. And so we'd love to get that or these cases to be taken under advisement as soon as possible. Again, the notice of publication was timely. I will say that that one notice that is outstanding, I did confirm it was signed and delivered. So the affected party has received that notice. With that said, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken, well, not taken under advisement, but that we can continue to either the April 14th or 28th docket.
Sounds good.
Special docket.
The exhibits are admitted into evidence. Mr. McClure did catch that issue problem. And the question is where to put them. So, Freya, well, first of all, Ms. Vance, when will notice be cured?
I think we should be good for the 15th because it was the 17th. Yeah, we should be fine by the 15th. 20 days. I calculated it right yesterday. Sorry. I should have counted my days. I apologize. Yes, we would be fine by the 15th.
By the 15th. Freya, how does that docket look?
The April 15th docket is the NOV docket, so I don't know if we'll have a technical examiner present that date. Otherwise, April 21st or 28th.
Sounds good. So, Ms. Vance, the 15th doesn't work. Pick another date.
The 21st.
The 21st. Freya, if Ms. Vance continues these two cases to that docket, can we hear them first?
Yes.
Just to get them out of the way? All right. So, Ms. Vance, will you continue these two cases to the 21st and we'll hear them first?
Yes, thank you. Appreciate it.
All right. And Mr. McClure, you didn't have any other questions for any witnesses on this case, do you?
Mr. Hearing Examiner, I had no questions for either of these cases.
All right. Thank you, Mr. McClure. All right, Ms. Vance, we're off the record in those two cases. Let's move on to Permian Resources, 25959.
Yes, good morning, Jackie McLean on behalf of Permian Resources.
Good morning, Ms. McLean.
And we do have one entry of appearance from Marathon.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of Marathon Oil Permian, monitoring only.
Thank you.
Thank you.
Go right ahead, Ms. McLean.
Thank you. In this case, Permian Resources seeks to pull all uncommitted interest in the Bone Spring Formation underlying a 477.66 acre, more or less standard horizontal spacing unit comprised of the west half of Section 1, Township 21 South, Range 32 East in Lee County. And this unit will be dedicated to the Minis 1 FedCom 401 and 501H U-turn wells. The exhibits submitted for this case include land testimony and corresponding exhibits of Mark Haddock, who has previously testified before the division and has been recognized as an expert in petroleum land matters. We also have geology testimony and exhibits from Chris Canton, who has also been previously recognized as an expert in petroleum geology matters. Finally, we include our notice testimony and copies of the notice letter, which was timely sent on February 4th and 10th, as well as the affidavit of publication from February 17th. And unless there are any questions, I ask that the exhibits be admitted for case number 25959 and that the case be taken under advisement.
Thank you, Ms. McLean. The exhibits are admitted without exception. Mr. McClure, who do you have questions for?
Mr. Hearing Examiner, I'll have questions for the landman.
Okay, that's Mr. Haddock. Would you like me to share the exhibits?
That sounds wonderful.
Okay.
I'm waiting for Mr. Haddock to turn on his camera.
I'm here.
Mr. Haddock, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Please spell your name.
Mark, M-A-R-K. Last name's Haddock, H-A-J-D-I-K.
Okay. And you've been admitted as an expert before this division in what field?
Petroleum land matters.
Great. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Haddock, I'm looking at your self-affirmed statement found on page 5 of 67. Yeah, and specifically, I'm looking at paragraph 4. Do you see where I'm referring to, Mr. Haddock?
Yes.
What would be the correct legal description for this proposed unit?
It's these are irregular shaped sections, so it is the west half of the section.
Would it be accurate to say that the correct description would include a listing of all the lots?
I think it's the same. It would be the same to list the lots as it would be to say the west half. Is it the west half? If you listed all the lots, it would also be the west half.
Is it more accurate to say that it would be considered the west half equivalent, but the actual legal description would be a listing of the lots and quarters that's included in the west half of that irregular section 1?
I don't know that I follow the difference in the two.
If you were putting together a communitization agreement, would the BLM require, or state land office require you to list out the lots rather than the west half equivalent?
I think that would apply whether it was a traditional section or not. I'm not sure what.
I guess if I were to ask you to amend this statement and the application to, and the CPAC to include the all the lots associated with this irregular section, which I'll add is very much irregular considering that it's a 1.5 miles tall rather than a mile tall. Do you understand what I'm asking for?
I do understand what you're asking for.
Now, looking at your C-102, it looks like you have the lots wrote out there, like lots 3, 4, 5, 6, 11, 12, 13, 14 in the southwest quarter. You sure I'm referring to?
Yes, I see that.
Okay, thank you, Mr. Haddock. I have no further questions, Mr. Hearing Examiner, but I do have some guidance from Ms. McLean.
Go right ahead.
And Ms. McLean, if we could get the application, amend the application to include the lots. And then if you want to have west half equivalent after it, that's fine. But it should be the lots and the southwest quarter of E. Redeker Section 1 is what it should read. And then if we could then conduct new notice of that amended application.
And I guess I follow Mr. Haddock's confusion on this because I don't recall this ever being required. I think that notice was provided that this is the west half of Section 1. We have the C-102s that show that in the exhibits. We can certainly amend the checklist to include that information, but I just don't understand why that's necessary or how that's important for granting this order.
Because the proper legal description would be the listing of the lots and the southwest quarter rather than saying the west half. It would be more accurate to say west half equivalent if you're going to say west half. But even then, that acknowledges that it's not the actual west half, it's just the equivalent of the west half. The Section 1 should also be listed as E. Redeker Section 1.
So is that going to be required now going forward for all applications?
It should have always been required.
And so I guess, are you saying that we need to just refile a new application? Or we can ask Freya to replace the one that's already in the file?
Well, we wouldn't replace the one that's already in the file, but you would submit to this same case an amended application, which then would allow the division to renotice it. And then you would, of course, renotice it on your end, the written and public, because I believe the same error is in both those notices.
Okay.
Ms. McLean, we can help you expedite this. I would think that if you were able to do that within the next couple of days, we could get this heard in a month from now.
We are going to be there for the April 28th hearing docket. Perhaps we could get it set on that one.
Okay. Yeah, that's a month from now.
So then I would just ask that the case be continued to the April 28th docket.
So you'll file a continuance then?
Yes.
Okay, we can do that.
And then Ms. McLean, we were also looking at the CPAC and the self-affirmed statement too. I think you already got that, but I didn't outright say it, I guess.
Yes. All right, we will do that.
Okay, we're off the record in this case. Thank you.
Thank you.
Thank you. Moving on to Marathon Oil 25961.
Good morning, Mr. Hearing Examiner, Mr. McClure, Paula Vance with the Santa Fe office of Holland and Hart on behalf of Marathon Oil Company. And yeah, I don't think that there are any other parties in this case. So
Go right ahead.
I will move on. So in case number 25961, Marathon seeks to pool the uncommitted interest in the south half of section 12, township 23 south, range 28 east, and lots 3 and 4, the east half of the southwest quarter and southeast quarter, which is the south half equivalent of a regular section 7, township 23 south, range 29 east, and that's all in Eddy County, New Mexico. And the pool involved here is the Culebra Bluff. Bone Spring Pool Marathon is also requesting a non-standard spacing unit. So we have included that pool information in the additional requirements in the CPAC. Marathon seeks to initially dedicate the spacing unit to the Valkyrie, Federal Com 501H, 502H, 551H, and 552H. I personally love the name because I love Wagner. So we have included the self-affirmed statement of landman Jeff Stout and then our geologist Preston Dupree, who have both previously testified before the division, and their credentials have been accepted as a matter of record. I will also point out that Marathon is only seeking to pool non-cost-bearing interests, so we're less some of the typical stuff like the proposal and chronology of contacts. And then, of course, we've included my self-affirmed statement of notice that was timely mailed out on February 13th, 2026, and the affidavit of notice of publication, which was timely published on February 14th, 2026. Unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that this case be taken under advisement at this time. Oh, you're on mute, Mr. Hearing Examiner.
Admitted without exception. Mr. McClure,
Mr. Hearing Examiner, I will have questions for the landman.
please.
Mr. Stout should be available.
Stout?
Stout. Yes, I
That
did.
name is not familiar to me. You said he was admitted as an expert? Thank you.
That's correct. I think he's there. There he is.
Mr.
Yes,
Stout, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you. Would you please spell your name?
Jeff, Jeff, last name Stout, Stout.
Okay, and Ms. Vance advised me that you have been previously admitted as an expert. In what field, please?
Landman.
Please go ahead, and Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Stout, I'm looking at your exhibit C2. I'm looking specifically at your interest breakout for track 3, which is on page 25 of 41. Maybe the next page down, maybe.
Yeah, I'm sharing my
Oh,
screen.
25, I think. I don't know if I said 23, but 25.
This one right here?
Yes, Miss Vance. Mr. Stout, do you see what Miss Vance is sharing here?
I do.
Do you see that track ownership breakout table that's on the kind of the right-hand side there?
Yes.
It looks like you only have 87.5% of the working interest accounted for. Is this a typo, or are we missing someone? Or I guess what is the explanation for 87.5% only being here?
They should be 100.
Okay, so then Occidental has 100% of the working interest in track 3. Is that correct?
That is correct.
Okay, if I were to ask you to make a correction to this exhibit to identify that, do you understand what I'm asking for?
I do.
And Mr. Stout, is that something you'd be able to provide to your attorney by the end of the day today?
Absolutely.
Mr. Hearing Examiner, I have no further questions for this
All right.
case.
Thank you. Ms. Vance, if you can get that submitted with a cover letter to explain the change in this exhibit, we will take this case under advisement at 5 p.m. today.
You got it. Thank you.
Thank you.
So I'm going to make that note, 5 p.m. Okay, let's go to Mewbourne Oil. These are cases 25963, 4, 6, and 7.
Good morning, Dana Hardy with Hardy McLean on behalf of Mewburn.
Good
And
morning.
we do have one other party.
I see that.
Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG Resources, just monitoring. Thanks.
Thank you, Ms. Kessler. Ms. Hardy?
Thank you. In these 4 cases, Mewburn seeks to pool 4 standard bone spring formation units underlying sections 1 and 2 of Township 22 South, Range 25 East in Eddy County. The 4 units will be dedicated to the Bills Mafia 1-2 FedCom wells. Our exhibits include the land testimony and exhibits of Brad Dunn, who has previously testified before the division as an expert in petroleum land matters, and the geology testimony and exhibits of Charles Crosby, who has previously testified before the division as an expert in petroleum geology matters. Our notice testimony and exhibits are included in Exhibit C. We did timely provide notice to all affected parties on February 4th, 2026, and timely published on February 12th, 2026. So with that, unless there are questions, I would ask that the exhibits be admitted and that these 4 cases be taken under advisement.
Thank you, Ms. Hardy. The exhibits are admitted without exception. Mr. McClure, questions?
Mr. Hearing Examiner, no questions, but other than guidance for Ms. Hardy.
All right, sounds good. Go right ahead.
I thank Mr. Hearing Examiner. Ms. Hardy, you don't happen to have a pen and paper for a pool code handy, do you?
Sure I do.
The correct pool code would be 96437. And that is the Happy Valley Bone Spring. Difference being that it's not the East Happy Valley that we have or that the applicant has here. We're going to need the CPAC corrected. We'll need the Form C102s corrected. Do you think those C102s is something Mewburn would be able to get to you sometime today?
I believe so, Mr. Examiner. I think we could do that.
Do we have your witness, Ms. Hardy? Do you want to ask?
Mr. Dunn, I do believe he's on.
Perfect.
Mr. Dunn, can you turn on your camera? There you are.
Yes. Can y'all see me and hear me?
Yes.
Now we can, yes.
Okay, great. Yes, I can get the C102s back today, no problem.
All right, great. So, Ms. Hardy, if you can correct the CPAC today and the C102s, submit that with a cover letter to the division. We'll take this case, these 4 cases under advisement at 5 o'clock.
Perfect. Thank you very much. We will do that.
Thank you. We're off the record in those cases. Let's go to Marathon Oil. It looks like we have one case, 25971.
Yes, excuse me. Good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of Marathon Oil Permian LLC.
Thank you.
Good morning, Jordan Kessler with EOG Resources, once again, just monitoring.
Thank you. Do we have someone from Gallagher Kennedy? Ms. Starnes, do you know?
I'm not sure.
Good
No, I
morning,
don't.
Serafina Saluba on behalf of Gallagher and Kennedy. Thank you.
Can you turn your camera on? I'm not sure who just entered an appearance, so if you could turn.
My camera is having issues at the moment.
Okay. And what did you say your name is?
Sure, my name. Actually, our other counsel is here and his camera is on. I will defer to him. Thank you.
Good morning, Mr. Hearing Examiner. I didn't get unmuted in time, but this is Dal Mullenberg from Gallagher and Kennedy, also here on behalf of Oxy, and we're just monitoring.
Perfect. Thank you, Mr. Mullenberg. Okay, Ms. Starnes, go right ahead.
Okay. In this case, Marathon seeks an order approving a standard overlapping spacing unit and pooling all uncommitted interest in the Bone Spring Formation underlying the east half of sections 15 and 22, Township 22 South, Range 32 East in Lee County. In support of these applications, we filed a revised hearing packet, with all of our usual exhibits, including the CPAC application, the self-affirmed statement of our landman, Jess Ritter, who has not previously testified or been accepted as an expert in front of the division. So we have included a copy of his resume and would ask that he be recognized as an expert and admitted as a matter of record. We also have included the self-affirmed statement of our geologist, Ben Brayman, who has previously testified and been accepted as matter of record. A copy of our self-affirmed statement of notice, which reflects that notice was timely sent on February 13th, as well as our notice of publication. If there are no other questions, then I'd ask that these exhibits be admitted into the record and the case be taken under advisement.
Your exhibits are admitted without exception. Let me first start with Mr. McClure. Do you have any questions?
Mr. Hearing Examiner, I will have questions for the landman.
All right. Now, Ms. Starnes, the landman has already been admitted as an expert, right?
No, he has not. We did
he
revise
has
our
not.
hearing
Okay.
packet to include a copy of his resume
Okay.
and ask that he be admitted today.
Would you call him and let's get him on camera?
Yes, Mr. Ritter.
Hey, Mr. Hearing Examiner.
I see you, Mr. Ritter. Would you please raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you. You can lower your hand. Would you please spell your name?
My first name is Jess, Jess, and my last name is Ritter, Ritter.
All right. Were you present when I went through qualifying a previous expert?
Yes, sir, I was.
Oh, excellent. Okay. So please give me education, then experience. What field are you? This is for petroleum landman. Is that what you want to be admitted as?
Yes, petroleum land matters.
All right, sounds good. Please give me dates when you did things so that I can try to put this in perspective. So go ahead.
Yes, sir. I attended Texas Tech University and graduated in December of 2022 and got my bachelor's degree in petroleum land management. And I had been working as a landman for ConocoPhillips for the past 3 years in both New Mexico and in Texas. And I manage large areas of responsibility related to land matters.
Okay, that's great. I need some more detail. So
yes, I manage different leases.
What do you do on a regular basis? What do you do?
Yes, sir. I manage different leases and contracts across Lee County, New Mexico to ensure development of oil and gas resources.
Okay. All right. Tell me more about what you do on a day-to-day basis. What sort of categories of things do you do?
I negotiate leases, negotiate JOAs, operating agreements, work with other companies to promote development, and also with accounting and finance to ensure different owners are correctly have funds correctly appropriated to them.
Okay, and what is your title?
I'm an associate land negotiator.
Okay. All right. Okay. Thank you. You're qualified before this division as an expert in petroleum land matters. Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Ritter, I'm looking at your unit recapitulation table in Exhibit C3 on page 39 of 77.
Yes, Mr. McClure.
Yeah, do you see on that table, I guess, there where you have Zoral Partners Ltd listed?
Yes.
Do you see how it's listed twice? I'm assuming that's a typo. Is that correct?
Yes, there's different ownership in the unit, and so we just put them on twice as an abundance of caution. There's a severance there.
There's, could you say that one more time, Mr. Ritter, about, tell me about the death severance, I guess? Is that what
Not
you're
a death
referring to?
severance. That was the wrong wording to use. Their chain of title comes from they have different chains of title.
Okay, but are we referring to the same the same 0.19%? Or is that two separate 0.19% then?
I believe it's different, but I would have to confirm to check.
Okay, so you don't know for sure if Zoral Partners has, well, essentially 0.19 times 2 or 0.19.
Yes, I know they were
Okay.
listed. I know the chain of title is, different chains of title coming into it. So they were listed separately, but I'd have to check and see if it's duplicated or not.
Okay, we'll definitely need to do that, but still asking questions, I guess. You also have them highlighted here as if the applicant's requesting that the division force pool them. Is that correct?
That's correct.
Okay, I'll come back to that here in a second, but if you look further down this same table on the same page where it says Chad Barb, whose wife is Marcy Barb, do you see where I'm referring to?
Yes.
Is it correct that the applicant is also requesting that or is requesting the division also force pool this person as well?
Yes.
Okay, I guess if I can now draw your attention to your commitment table in Exhibit C-6, should be page 64 of 77.
Yes.
Do you see like 4 entries down where it lists Chad Barb Development LLC?
Yes. And
is this a different Chad Barb than what we were talking about on the unit recapitulation table, or is this the same one?
It is the same Chad Barb, and I believe I know where you're going with it, but
Yeah, it looks, well, yeah, I mean, clearly
Yeah.
you have it listed as committed. Is it accurate that they're committed or are they not committed?
so they have executed the joint operating agreement, but they have not provided the communitization agreements needed for us to develop the leasehold.
Now you say joint operating agreement. Are they not the overriding royalty interest owner?
Or excuse me, they haven't provided the copies of all the physical copies of the ratification. We have to have
Okay,
the
so
physical
then
copies of the ratification to pull them.
Okay, so then I guess is it accurate to say that they're committed or they're not committed then, I guess?
I think it's safe to say we're working with them. We're mostly there. We're just waiting for them to send the physical copies in the mail.
Okay, then so it would be more accurate to say that the point at this hearing today, they are uncommitted and that the applicant is still requesting the division to force pool them. Is that correct?
Yes, Mr. McClure.
Okay. Mr. Ritter, if I can also draw your attention further down to Zoral Partners down there at the bottom.
Yes.
Here you have them listed as committed and signed under a JOA. Is that correct?
That's correct.
Okay, then is the applicant still requesting the division to force pool these persons then?
It's the same, yes, the same situation with Chad Barb.
Okay, so then you don't have the signed JOA in your possession at the moment. Is that correct then?
I have the JOA, but not the signed ratifications of the communization agreements.
So the JOA is signed and they are signed and they're part of the joint operating agreement. Is that correct?
That's correct.
Okay, then tell me one more time what you're waiting on, I guess, before you would consider them not needing to be force pulled.
The executed communitization agreements.
I guess, do you have any reason to think that they signed the JOA, but they're not going to sign the COM agreement?
It's just out of abundance of caution. We cannot, produce these wells unless we have all ratifications of the communization agreements.
And I guess if I were to ask you to correct the listing for Chad Barb up above to being uncommitted on this table, do you agree that would be accurate? And do you understand what I'm asking for?
Yes, Mr. McClure.
Okay, then looking back at your unit recapitulation table in Exhibit C3. Actually, let me get scrolled back up. Page 39, looks like, where we were talking about earlier.
Yes.
Okay, I guess confirm for me one more time on the Zoral Partners. Their ownership is either 0.195311175 or double that. Is that correct?
That's correct.
And is that research that you would be able to conduct by the end of the day?
Yes, Mr. McClure.
In addition to that, if I were to ask you to I guess that'd be the only correction on this one, actually, because you're saying Chad Barb's is not. Okay. Okay, do you think both the research and any necessary corrections to this table, and by necessary corrections, I mean either remove Zoral Partners as being listed twice. Let me restart to make it clear. The plan would be that if there is only 0.1953% attributed to Zoral Partners, you would only list them once here. Is that correct?
That's correct.
And then if they in fact is double that and they have two different instances of 0.1953, you would then leave it as is. Is that also correct?
I believe we would add them together if I'm understanding your question correctly.
Okay, so instead of saying 0.1953 twice, you would double it and list them only once and then just have that doubled percentage. Is that correct?
That's correct.
Okay. And do you believe you could conduct the research and correct both of these exhibits by the end of the day?
Yes, sir.
Mr. Hearing Examiner, I don't have any further questions for this case.
All right, Ms. Starnes.
Yes.
We will leave the record open until 5 o'clock today for you to submit a cover letter along with the corrected exhibits that Mr. McClure has requested. Is that okay with you?
That's wonderful. Thank you.
Right. We're off the
Ms.
record in this case.
Yes, Mr. McClure.
Ms. Starnes, you knew which exhibits I was asking for. Is that correct?
Yes, the commitment chart with the pooling recapitulation as well as the ownership commitment status chart, correct?
Well, the unit recapitulation chart and then the commitment chart. Yeah, maybe that's what you said. I'm sorry.
Okay.
Exhibit
Perfect. Yes, we're on the same
C3 and
page.
C6. I apologize, Mr. Hearing Examiner. I was just checking on that for sure.
Makes sense. Thank you. All right, Ms. Starnes, if for some reason you're not able to submit them by 5 o'clock, then please continue the case to another docket.
Absolutely.
All right, we're off the record in that case. Let's go to Matador Production. We have two cases, 25976 and 78.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of Matador Production Company.
Thank you. Go right ahead.
I was going to say, I don't think we have any other appearances. So in these two consolidated cases, Matador seeks to pool all of the uncommitted interests in the Wolfcamp Formation underlying the east half of sections 28 and 33. In support of these applications, we have timely filed our exhibit packets that include the normal suite of exhibits, the compulsory pooling application checklists, the copies of application, the self-affirmed statements of the landman Isaac Evans, and the self-affirmed statements of the geologist Andrew Parker, both of whom have previously testified in front of the division and whose credentials have been accepted as a matter of record. The self-affirmed statements of notice, which reflect that notice was timely sent on February 13th, and the notices of publication. And if there are no other questions, we'd ask that the exhibit to be admitted into the record and the cases be taken under advisement.
Thank you. All exhibits are admitted into evidence. Mr. McClure?
Mr. Hearing Examiner, I'll have questions for the geologist.
Okay. Perfect. Andrew, Mr. Parker, are you here?
Good morning, Mr. Parker. Would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Will you state and spell your name?
Andrew Parker, AndrewParker.
Okay. And I recognize you as a previously admitted expert in what field?
Geology.
Okay. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Parker, I'm looking at your self-affirmed statement in Exhibit D, page 29 of 41.
Okay. All right. I'm with you.
Okay, I'm looking, Mr. Parker, I'm looking at your paragraph 5, where you refer to, however, it is MRC's understanding that within the industry, the consensus is to refer to this target as Wolfcamp. You see where I'm referring to?
Yes.
Can you provide me a little bit more context as to what you mean by it's the consensus of the industry?
Yeah. The nomenclature for this zone, I think is been a little bit ambiguous over the history of its development. So, some people refer to it as Wolfcamp D, and I think we've heard from other cases similar to this one that there's just still ambiguity out there as to whether or not, for instance, like where you would put a Pennsylvania top or something like that in this part of the section. So it's our opinion that this package that we're targeting here is connected to and part of the gross Wolfcamp petroleum system, which is why we link it here. If we don't have any sort of data or anything to confirm really where you would put a true like stratigraphic base Wolfcamp in this section.
I guess, is it more accurate to say that's Matador's position rather than industry's position then?
Well, I mean, I would say there's not a golden spike or an academic reference out there that everyone can point to for this. And I would say it's my experience in conversations with other operators, also seeing how other geologists have testified in similar cases, that it's a similar opinion. Maybe it's not just fair to say that like blanket across the industry, because there's not, like I said, a golden spike or something like that. But in my experience, all the geologists that I've talked to, the cases that I've been, privy to here, that seems to be the most common opinion. And I haven't heard an opinion that goes another direction.
Would it be more accurate to say that identifying the top of the Wolfcamp D and even agreeing upon terminology of what to call the Wolfcamp D, there is not a consensus within industry, rather than there not being papers that identify Wolfcamp D? Would that be more accurate to say?
Yeah, I think so.
So are you aware, I guess, of the papers I'm talking about that do call out Wolfcamp D and refer to it as Pennsylvanian aged rock? I believe there's a BLM paper, and then EIA, I believe, has a paper out as well.
Yeah, I'm not sure if I'm familiar with those exact references.
I guess, would it surprise you if there's official papers that identifies Wolfcamp D, not in necessarily this specific area, but Wolfcamp D overall, and identifies it as Pennsylvanian age formation?
No, it wouldn't surprise me. It would surprise me. It would surprise me if there was like concrete biostratigraphic evidence that supports that. In out here in this part of the basin, that would surprise me because I haven't seen that. But for someone to interpret a Pennsylvania top, based on some other model or something, that wouldn't surprise me either.
And I guess, would it surprise you to, which I'm assuming is maybe where you were going, but I guess my question, would it surprise you that some operators even identify a Wolfcamp E, for instance, down below where they identify a Wolfcamp D?
That might. I haven't heard anyone say Wolfcamp E.
Yeah, we have an operator that identifies the Wolfcamp E below the Wolfcamp D. The only point being that confirming you're in agreement that there is some inconsistency as to what operators identify as the Wolfcamp D and where they identify it at, I guess. You're in agreement, yes?
Yes, there's definitely a lot of inconsistency for that.
Having said that, are you in agreement that there is Pennsylvanian age rock above the top of the Strawn?
Yeah, for sure.
And is it correct then that your concern here is you're not sure where the top of that Pennsylvanian is based off the logs?
Yeah, that's correct. There would be a bunch of different ways to interpret that, and without having some concrete biostratigraphic evidence, it could go either way. I think there's a lot of different ways to interpret it.
Okay, I'm looking at your Exhibit D3, the cross section here on page 34 of 41.
Okay.
It looks like your target goes all the way down to, well, just looking, well, in the middle one, 12,500. Do you see what I'm referring to?
Yes.
Where did you, I guess, what is the bottom of that target based upon?
I mean, that's mostly just a log signature of what we consider to be, the highest quality potential reservoir that you would want to target with your wellbore. It's the most organic rich. It's the highest porosity. It's got the high, we're just encapsulating the kind of highest net to gross where we think the oil concentration could be.
Okay, and on that middle log there, it looks like it's like 130 feet or something above the Strawn top, something like that.
Yeah, that looks about right.
Do you believe the Cisco Canyon to exist in this area of the basin?
Yeah, I think some of that rock is Cisco or Canyon equivalent.
Do you believe the Cisco Canyon is only 130 foot thick here? The Cisco and Canyon together?
That would be as ambiguous as everything else we've discussed. I mean, that's up for interpretation, but again, I don't have concrete evidence to suggest one way or the other. It wouldn't be out of the question for it to be only 130 feet thick.
Where in this target is these two wells? I believe there was two wells in this case I'm looking at, but however many wells there are, where are they planned to be actually be targeted at? Or excuse me, where are you planning? Where are they going to be landed at on this cross section?
You know, I mean, as this play is developing across the basin, we're seeing operators, you know, target differently throughout the entire yellow shaded box. So I mean, we would like to. I think that we have, you know, 2 or 3 potential landing zones anywhere within this yellow box that we would like to be able to test out.
Do you understand that what Matador is asking for here is to pull the wolf camp and only the wolf camp, correct?
Yes.
And do you also understand that the division considers any Pennsylvanian rock to not be a part of the wolf camp?
Yes.
So do you understand that with this particular case, Matador would be limited to only formation above the essentially above the Cisco?
Yes.
With that in mind, how would you identify the top of the Cisco? Because that's essentially what you're saying. You're not going to be able to identify it. Is that correct?
Yeah, I mean, there's nothing concrete here to pinpoint a Cisco top.
So how does Matador propose to ensure that its wells are only landed above the Cisco and not below?
I mean, I'm not sure that we can without having, again, like concrete biostratigraphic evidence. I mean, so the way that we view this package, the reason we call it Wolf Camp is because, or treat it as Wolf Camp, is because we believe this rock to be part of like the greater Wolf Camp petroleum system. This is a source rock to overlying Wolf Camp. You know, conventional reservoirs and even unconventional reservoirs. They are very oil prone source rocks, just like we see throughout the Wolfcamp, whereas in Pennsylvania pools, you know, more specifically like Atoka and Morrow pools, those are very gas prone source rocks. So there's that sort of, well, you know, difference in the nature of these petroleum pools. I mean, you know, just trying to treat it as, you know, in terms of fluid behavior and things like that. That's, you know, that's kind of how we're doing this.
So is it Matador's position that the upper pin and that the wolf camp should be completed together, I guess? Is that where you're going with that?
I think they're in connection. I think they're part of this. You know, if these rocks were in fact Pennsylvania age, they're still, you know, interacting with and behaving along with, you know, Wolfcamp rocks, because some of the rocks in this yellow box I think are for sure Wolfcamp. Whether or not some of them are Penn, I don't know.
Well, just to give you some context, I guess is where I'm going, is I'm trying to figure out whether you're going to be able to limit your completions to just the wolf camp. And if not, if the other route might be to try to put a pool together that includes both the upper pin and the wolf camp.
I mean, our goal is to target in the yellow box and keep our completion within the yellow shaded box.
Mr. Hearing Examiner, it looks like their attorney might want to talk to them. Do you want us to give them a break to confer, or?
It looks to me like Mr. Rankin wants to address both you and I. So go ahead, Mr. Rankin.
Thank you very much, Mr. Hearing Officer, Mr. McClure. I do want to point out, I think a disconnect that's we're hearing from the division today between what Mr. Parker's testifying to and what the statute provides for in terms of what the division has authority to pool. Okay, and that the disconnect that we're hearing is Mr. McClure is focusing on a geologic issue, which is time-based, and Mr. Parker can address this as further. But there's a question about time-based formation, okay, where in geologic time the target interval is. And as we heard from Mr. Parker, that question is ambiguous because people haven't done the studies to determine precisely where in geologic time this target interval lies. But what he did testify to is that this interval that they're targeting is the source rock for the oil that constitutes the Wolfcamp Pool. And when you look at the division's authority to force pool under statute 70-2-17, what the division has authority to pool is the reservoir that constitutes a spacing unit. So you'll have to look to what the common source of supply is, not necessarily the formation. So when you look at 70-2-17C, you identify first what the common source of supply is, and it's not going to be based necessarily at the end or beginning of whatever a formation may be. So here we have testimony uncontroverted that this target interval is part of the Wolfcamp Pool because it is the source rock. And based on that, we have no other evidence to the contrary. This is part of the same interval that is being developed above immediately as part of the Wolfcamp Pool. So I would ask that the division, take that into serious consideration, because when you look at the statute, and I'm happy to share it on my screen, the issue is not what formation you're in, and a hard line between two potential formations does not dictate where an operator can or is able to develop. Rather, it's the reservoir itself that, in other words, what constitutes the common source of supply. And so, and Mr. Parker can further elucidate his opinion on this, the distinction between geologic time on the one hand, which is what Mr. McClure is driving at, and the common source of supply, or the reservoir, which is what dictates the formation of spacing units. So as long as it's all part of a common source of supply or reservoir, that is what constitutes the spacing unit. And that's what the division has authority to pool. And it's not limited to one formation or another. So with that, I would ask, if it's helpful, I can do some redirect on Mr. Parker, but I do believe he offered the testimony that would be necessary for the division to proceed to include this target as part of the Wolfcamp Pool.
All right, let's do this, Mr. Rankin and Mr. McClure. Let's take a break. Mr. McClure, you and I will talk offline. Let's see what you think of that argument. Let's see how you want to proceed. And then, Mr. Rankin, I'll give you an opportunity to do redirect on Mr. Parker to flesh out the evidentiary record. But let's take a 10-minute break. It's 10:22 now. Let's come back on the record at 10:32 and continue this.
Hi, everyone. The hearing examiner just wanted me to let everyone know that he and the technical examiner are still discussing the issues. You may have seen his message in the chat, but also wanted to alert you to that. We're just going to take a little longer break. Thank you.
All right, it is 10:45 a.m. We spent a little longer than we thought we were going to discussing the issue amongst the technical examiners. Mr. Rankin, did you want to redirect your witness?
Mr. Hearing Officer, if it would be helpful for the division, I would be happy to redirect to some extent to address, in my view, the issues that are determinative.
Okay, and also I'm going to let you know that we are going to be asking for digital logs. So I don't know how quickly you want to supply those. I'm not pressuring you in any way. We can leave the record open after this redirect, and if there's any cross from Mr. McClure or not, we will take the case under advisement as soon as we get the digital logs. So why don't you think about that, Ms. Starnes, while Mr. Rankin is dealing with his witness. Mr. Parker, are you there?
Weird.
Mr. Parker, I want to just follow up on some of your previous testimony based on the questions that you received from Mr. McClure. And I've got up here your exhibit D3, which is the cross-section showing the target interval for this project. And you've highlighted in yellow the target that you've identified here. And I understand from your testimony that the yellow that you're targeting in this zone is in your opinion, part of a common source of supply that constitutes the Wolfcamp Pool. Is that correct?
That's correct.
Will you please just expound on that a little bit and explain the basis for that opinion?
Yeah, again, it's just the nature of these source rocks. They're a marine type 2 kerogen that are oil prone. And these source rocks are part of the petroleum system that does source overlying, Wolfcamp age rocks, and that they're distinctly different than some of the other source rocks that are deeper in the pin, that are much older than this. And it's our interpretation that this package of rocks is not segregated from the overlying units, and they are part of the same petroleum system.
And in your view, would that common source of supply extend up to what you've indicated on this exhibit as the top of the Wolfcamp?
Yes.
And just to be clear, will the proposed target drain solely from what you've identified or you believe to be the Wolfcamp common source of supply here?
Yes.
And in your opinion, would this be properly designated as an oil pool?
Yes.
Okay, not a gas pool, correct?
Yes, that's correct.
Okay. I think just in terms of characteristics, I think you touched on a little bit, but I want to make sure I understand, and maybe the division understands the distinction here between geologic time and a reservoir. You touched on this a little bit, that you don't have what you would need to really nail down where the geologic boundary is in terms of time. And maybe, Mr. Parker, if you could explain whether that's even possible in this circumstance, or in some circumstances, if it's ever possible, is there ever always going to be a clean line between geologically and geologic time between two different formations?
Yeah, it's not always going to be a distinct boundary. Classically speaking, the Pennsylvania and Permian boundary, where it is better defined, globally, is pertaining to places where there's a significant unconformity between the two. And defining that unconformity in rocks that are, either uplifted or in a shallower environment is easier to do. Whereas out here where we are at the basin floor, at this point in the late Penn to early Permian, the Delaware Basin had effectively formed and was a deeper depression than it was earlier in the Pennsylvanian or Mississippian, let's say. So the basinal depression was here, and the deposition of these rocks in the basin floor, was really more or less continuous across that time that is represented as an unconformity up, in other parts of the shallower parts of the basin or other parts of the world, or, other places in the country. So it's just, because of that more or less continuous, relatively speaking, continuous deposition across this, deep basin floor marine package here, putting a geologic boundary on that is very difficult to do compared to other places.
So
does that answer your question?
I think it does. And I want to just follow up on that a little bit. You heard Mr. McClure ask you a couple of questions about papers that he was referencing, maybe by BLM or maybe by the Energy Information Agency. Do you recall those questions?
Yes.
Were you familiar with those papers?
I'm not familiar with those. I mean, I may need a refresher on it.
Okay, but whether or not the BLM or any other agency or any other geologist identifies something as being Penn or Wolfcamp, does that change your opinion in any way that this target that you've identified on your exhibit is part of the Wolfcamp common source of supply?
I mean, if someone's putting a specific Pennsylvania boundary here, it would depend on whether or not that's just a stratigraphic interpretation that's based on, like a sequence stratigraphic model or some sort of depositional model, versus having, some other sort of age data that would constrain that more. Whether that could be, some sort of radiometric dating, or what would be more acceptable, I think, would be biostratigraphic dating. If those papers were to reference that and have definitive data to support that here, then that would be worth noting.
But I guess my question to you, though, Mr. Parker, is the distinction between whether someone identifies an interval as being Pennsylvanian in age or Wolfcampian in age or Permian in age.
It doesn't change my thoughts on what I'm testifying here as to the nature of the pool and the fact that the geologic time boundary is really indifferent to the behavior of the source rocks and the pool and the petroleum system that I'm talking about here.
Okay. And in your awareness, Mr. Parker, just to be clear, your responsibility, explain what your responsibilities include at Matador. Your responsibilities as a geologist at Matador. What are your responsibilities?
I'm the executive vice president of geoscience, so I head the geology department here. I head all exploration efforts. I head all, data collection, technical efforts, development. I supervise, the entire geoscience team here and across all asset areas for the Delaware Basin.
And you in the Wolfcamp as a principal target, not just of Matador, but of all operators in the Delaware Basin, agree?
Yes.
And so you're familiar with what other operators are doing in the basin as well as what Matador is doing, correct?
Yes.
And are you aware of any operator in the Delaware Basin that is identifying this targeted interval not as being within the Wolfcamp pool?
No. I mean, from what I understand, other operators that are drilling, this package of rock is treating it or viewing it the same as we do.
Okay. And again, I'm distinguishing between geologic age and a pool. You understand that?
Yes.
Okay. I think I may have addressed all the questions I have. Mr. Parker, is there anything further that I didn't ask you that you think would be useful for the division to understand as part of their assessment here about whether this target is part of the Wolfcamp pool?
No, not that I can think of. I think we've covered it.
All right, thank you.
Yeah,
Thank you.
one for consideration, Mr. Hearing Officer and Mr. McClure, I just want to make the point that in the landman statement that we've included here, Mr. Evans does make clear that there's no ownership severance from the top of the Wolfcamp down anywhere.
Okay.
So whether this, whatever pool the division deems appropriate is acceptable to Matador.
Okay,
However,
thank you.
Yeah, the evidence we believe supports it should be in the Wolfcamp.
All
That
right,
said, we're interested in developing this in a timely way. Okay, and
Thank
that's
you, Mr.
that's the key.
Franklin.
Thank you.
Appreciate it. Mr. McClure, any follow-up?
I was just thinking about that last thing on the landman, but no, I don't think I have any further follow-up. Thank you, Mr.
All right.
Examiner.
Do you want to be very specific about the digital logs that I brought up?
Yes, Mr. Hearing Examiner. Ms. Strauss, essentially what we're looking for is to confirm on that cross-section on page, I scrolled to the landman exhibit, but I'm going back down to exhibit D3. There's 3 different logs depicted here, or 3 different wells with logs depicted here. You see what I'm referring to, Ms. Strauss?
Yes.
What we want to do is we want to please check and see if every single log that was used to construct this is currently submitted in TIFF format to the division in the well file. And if not, we want every single one of these logs to be submitted. You understand what I'm asking?
I think I do, yes.
Do you think Matador would be able to provide you with all that by the end of the day?
I would have to confer with Mr. Parker on that, but
Is he available? Let's
Mr.
get an
Parker,
answer.
are you still here?
Yeah, I can get it by the end of the day. So you want TIFF images of the original raster logs for these wells?
Well, our system only accepts it in TIFF. So yeah, that's correct.
I'm sorry, can you say that again?
Our system only accepts it in TIFF format. So
Okay.
that is correct. That's how it'll have to be submitted to our system.
Are you wanting a TIFF that's just a snapshot of this view here for each individual log, or are you wanting a TIFF of the entire well log?
We want
All
the entire well log. In theory, it's already submitted to the division because operators are required to do so under rule.
Yeah,
But
I'm sure
we want
these
to double check that.
Yeah, the raster images are probably available on NMOCD, but we can get them to Holland and Hart and have them submitted to you today.
Can I ask a quick question for clarification?
Please.
Mr. McClure, are you satisfied? I mean, are you satisfied with a raster image of that, or do you want a digitized version of the original raster? I don't know if, just to be clear, I don't know.
Just the tip of it will be fine.
Okay.
Yeah, it sounds like they don't.
Yeah, we don't need
know
the
that
LAS or anything.
Yeah, the LAS file would be a different issue.
Yeah. Okay.
Yeah.
So
We don't currently.
Okay.
Go ahead. I'm sorry, Mr. Hearing Examiner.
All right, we're gonna move on from this case now. So, Ms. Starnes, please submit a cover letter with those three, documents when you.
Should I
when you
file them as revised exhibits D3 or just supplemental exhibits, or do you care one way or the other?
Let me ask Mr. McClure. Mr. McClure?
I apologize, Mr. Hearing Examiner. I was reading a message. What was the question, Mr. Or go ahead.
Do you want Ms. Starnes to file those digital images in TIFF format as supplemental exhibits or as revised exhibits D3?
No, they won't be able to submit them into the case file. They need to submit them to the well logs.
Okay.
If they have any questions, they can definitely feel free to reach out as to how to submit that. But essentially, when you do a submission, it's like EP well log or something like that is what the submission type will say.
Okay, and then I can do a cover letter afterwards to let you know that they've been uploaded.
That's perfect.
Okay, perfect.
And then, Ms. Starnes, that cover letter will just confirm that you've already uploaded those images, and then we'll be able to take the cases under advisement.
Okay, thank you very much. I appreciate it.
All right. If you need more time than 5 p.m. today, please work it out with Freya.
Okay, I will.
All right. Thank you.
Thank you.
Thank you. We're off the record in those two cases. Let's see. We have 3 more cases for Mr. McClure, and then we're going to recall the Occidental Permian cases before he leaves us. So let's go on to Coterra Energy 25977.
Good morning, everyone. Dina Bennett on behalf of Coterra Energy Operating. And I'm trying a new audio format today, so I'm hopeful that it's working better than my prior audio.
Okay, I hear you clearly, and there's no other parties, so please proceed.
Thank you. In case 25977, Coterra is seeking an order from the division reopening order number R24129 to add an initial well. Order R24129 was issued in December 2025, and Coterra is requesting to add an additional well, the Pintail 232635. And we provided in the exhibit materials a new compulsory pooling application checklist that includes the new well that Coterra is asking to be included in the order. And I've also included the self-affirmed statement of Keaton Curtis and Travis Sparks, landman and geologist for Coterra respectively, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. And I also included my notice exhibit that shows that notice was timely mailed and that publication was timely. In Mr. Curtis's materials, we also included in his self-affirmed statement, a statement that he has reviewed the pooled party list from the prior case and that there are no changes, and we included an updated summary of contacts. So with that, I would ask that the exhibits in case 25977 be admitted into the record and the case be taken under advisement.
Thank you. Admitted without exception, and I believe we can take this case under advisement.
Thank you very much.
Calling now EOG Resources 25989.
Thank you very much, Mr. Hearing Officer Adam Rankin with the Santa Fe Office of Paul and Hart appearing on behalf of EOG.
Thank you.
Good day, Mr. Hearing Officer. Good day, Mr. McClure. In this case, EOG is seeking approval for a unit expansion that has already been authorized and approved by the State Land Office. The expansion would include a single 160-acre state lease into the existing unit area that comprises the Wolfcamp and Bone Spring formations. As I noted, this is a state unit, voluntary unit agreement. EOG is 100% working interest owner in the expanded acreage. There are no additional overrides in the expanded acreage. However, we went ahead and noticed all existing overrides in the existing unit for purposes of notice, even though it's not required. And also the State Land Office has already provided final approval of this expansion, which we have included as part of the exhibit packet. Nevertheless, we went ahead and included the geology statement from the geologist as well, showing that the acreage is continuous, includes the Bone Spring and Wolf Camp over the expanded acreage, and that the acreage is expected to be part of the same development pattern. So with that, Mr. Hearing Officer, unless there are specific questions, both witnesses have previously testified and have previously been authorized by the division to testify in their respective areas. We ask that this case be taken under advisement by the division.
Your exhibits are admitted without exception. Would you call your landman?
Sure. Ms. Sykes, are you available?
Yes, I am.
Ms. Sykes, I can't barely see you. It's dark in the room, but okay. But I recognize your name and I know that you've been qualified as a petroleum landman before this division. Would you raise your right hand? Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Sykes, I'm looking in our case file for the original order, that being order R-23057. The unit agreement that we have on hand looks like it's signed by EOG only. Is this the executed unit agreement, or should there be additional signatures on this?
I do not. Let me pull up the original case file on that.
I guess a better question is, do you know if the division has the executed unit agreement on file, I guess?
If y'all do not have the fully executed version, we can certainly provide that.
How many signatures should be on the fully executed unit agreement?
It's gonna be all of our, I actually do not know the full count on that, but
It's
that is
more
something
than
that
EOG?
It is more than EOG, correct?
Okay, so is that, I mean, I'll have more questions, but just a quick question in regards to that. Is that something that you would be able to provide by the end of the day?
Yes.
Okay. Looking at this exhibit, or this case, excuse me, specifically, is it accurate to say that only exhibits A and B of the original unit agreement is being amended?
Yes, that is correct.
Okay. In the original unit agreement, I believe there was a obligation well of a single wolf camp. Is that correct?
Yes,
Has that wolf camp well been drilled and completed now?
it has.
Okay, so I'm looking at the approval letter from the State Land Office. It's on page 17 of 35.
Are we talking about the amended one or the original?
Now we're talking about the amended one, but specifically, I would like to draw your attention to the State Land Office approval of the amendment. I see where you're going. On this, do you see on here where it talks about, looks like 4 new obligation wells?
Correct, yes.
Okay, so my understanding of this is correct. EOG is now going to have an additional 4 obligation wells as a part of this expansion approval.
Yes.
Okay. Ms. Sykes, thank you. I don't have any further questions, Mr. Hearing Examiner. Just the guidance. I'd like to see that executed unit agreement.
Thank you.
Mr. Rankin?
We'll make it happen.
Okay. If you can get that into us by 5 o'clock today, we can take this case under advisement.
Mr. Hearing Officer, I think Mr. McClure will make that happen today.
Thank you.
And just to be clear, it's just a upload to the case file. Is that where you want it to be?
With a cover letter?
Correct? Okay.
I did want to add real quick, Alden, the geologist, has not testified before, so she'll need to be sworn in.
Thank you for bringing that to my attention. I apologize for overlooking that. Mr. Hearing Officer, I apologize. The hearing, the geologist did not previously testify before.
Well, we don't have any questions for the geologist today, so in the future, we'll get her qualified.
Mr. Hearing Examiner, if I could offer one more bit of guidance for Mr.
Yes,
Rankin.
please. Yeah.
Mr. Rankin, if we could submit that to both case files, the original one and this amendment one, because we need it in regards to the ordering paragraphs in R23057.
We'll make that happen.
Thank you.
Thank you, Mr. Rankin. Thank you, Mr. Hearing Examiner.
All right, we're off the record in that case. Let's go to Oxy USA 26017.
Good morning, Mr. Hearing Examiner, Dal Mullenberg of the Santa Fe office of Gallagher and Kennedy on behalf of Oxy USA Inc. And I understand that we have an entry of appearance from EOG Resources.
Good morning, Mr. Hearing Examiner. Jordan Kessler on behalf of EOG Resources monitoring this case.
Thank you, Ms. Kessler. Go right ahead, Mr. Mullenberg.
Thank you, Mr. Hearing Examiner. I'm here today on behalf of Oxy USA Inc. Oxy seeking an order from the division regarding the Party B's federal and state exploratory unit to be established through a unit agreement. The exhibits include a form of unit agreement that has been preliminarily approved by the BLM and the State Land Office. The proposed unit consists of a unitized interval of all depths 100 feet or more below the base of the Delaware Formation on an approximately 8,768 acres on state and federal lands consisting of 54% of federal lands, 18% unleased federal lands, and 27% state lands. And they're located as indicated in the application. Oxy's continuing discussions with BLM, the State Land Office, and working interest owners toward a final unit agreement. And Oxy will provide a copy of the final unit agreement once it's completed to the division. The hearing packet we've submitted includes my self-affirmed statement regarding the timely notices sent on March 2nd. With the standard information with that packet. Our other exhibits include the self-affirmed statement of Ms. Courtney Carr, who has previously been accepted as a petroleum landman with her credentials accepted as a matter of record. Her exhibits include the preliminary approved unit agreement and lands information. Also, we have the self-affirmed statement of Ms. Catherine Velasquez, who was qualified earlier this morning as a petroleum geologist. And her self-affirmed statement includes the geology exhibits. Both are available online for questions if you have any. And at this time, I request that all exhibits be admitted with the understanding you can admit or not admit the CV of Ms. Velasquez and for the matter to be taken under advisement.
Thank you, Mr. Molenberg. All your exhibits are admitted, including the CV, but we'll deal with qualification in the future unless we have a question now for that witness. Mr. McClure?
Mr. Hearing Examiner, I'd like to ask a question of Mr. Molenberg first, and depending on whether he knows the answer, I guess we might have to go to the landman perhaps.
Go right ahead.
It's about notice. So, Mr. Molenberg, in context of like working interest owners, royalty interest owners, overriding royalty interest owners, which groups of persons were provided notice of this case?
The working interest owners and mineral title owners.
For the entirety of the proposed unit?
For the entirety of the proposed unit, yes. And we did not provide notice to overriding royalty interest owners.
Okay, so to confirm, it was the working interest owners and the mineral interest owners, is that correct?
That's correct. And if you have any questions about the details, my understanding is Ms. Carr is on the line and can answer those questions.
If you're confident in your response, then that's fine with me.
I am. Thank you.
Okay, Mr. Mullenberg, I don't have any more questions, but I do have guidance. I'm looking
Thank
at
you.
your cross section in Exhibit C4, page 135, or I
Okay.
thought it was 135. Oh, I had in 145, not 135. Very confused there for a second. If I were to ask for this exhibit to be amended to include the API numbers for each of these logs, do you understand what I'm asking for, or should we ask your geologist?
I understand, and I expect that the API numbers would be available. If you want an acknowledgement of that from the geologist, I believe she's available, and I expect we can quickly provide an updated exhibit.
Do you believe you could do so by the end of the day?
Hi, Catherine Velasquez here, geologist. I see no problem providing it by the end of the day.
Yeah. Thanks for that. I wouldn't be preparing it, so very well.
Okay, thank you, Mr.
We can do that.
Hey, thank you, Mr. Mullenberg. Thank you, Mr. Hearing Examiner. I have no further questions for this case.
All right, Mr. Mullenberg, as long as you can get that evidence to us with a cover letter explaining what you are submitting and upload it into this case, we will take it under advisement at 5 p.m. today.
Very well. Thank you very much. We'll do that.
Thank you. I'm going to recall 25933 and 25994. Ms. Vance?
Yes, and I just got a text message from Miss Bennett saying that she got a message on her team saying, sorry, you.
Is Miss Vance cutting out for you too, Mr.? Oh,
Yes, she is. Ms. Vance, try your microphone again.
Hello? Can you hear
You
me?
got a text from Miss Bennett and then you cut out.
I got a text from Miss Bennett saying that the recording stopped. So I'm not sure, just relaying the message, basically.
Ms.
Yes.
Chance, do you see anything wrong with our AI recording?
I do not. I got the same message from Miss Bennett. I don't
Okay.
show that it stopped. It's still going. So
Okay,
I'm not
go right
sure
ahead,
what
Ms.
happened.
Vance. We're
Okay.
back on the record in your cases.
So I'll provide a quick summary. One, I think my colleague, Mr. Rankin, already went through pooling authority arguments and discussion, so I'm not going to get into that. I did go back and look at the rules specifically related to notice. And what I see is that it requires, initial hearing notice, the name or general description of the common source or supplies or supply or the area of the order sought affected. And we did include that. And then as far as the public notice goes, again, if the application seeks compulsory pooling, et cetera, the notice shall contain a legal description of the spacing or geological area. Again, we provided the general required information both in our notice, and that was also included as a part of the public notice. So just want to put that in there. However, we did receive waiver of notice from Coterra. And I will put that up on the screen really quick. I did black out one part. But you can see here our landman, Miss Mullen, did reach out to Coterra and they have waived the notice, understanding that there was a Scrivener error. You'll see Amy Lindsay, she is with Coterra. So I would just ask that we file this as a part of a revised hearing packet today, and that these cases be taken under advisement.
Mr. McClure?
Mr. Hearing Examiner, Ms. Vance might be able to address my questions about notice. Miss Vance, I haven't looked at the second case yet, but in case 25933, it looks like there was two parties. Cimarex/Patera was provided notice, and Pomera, how you pronounce it, was provided notice. You see where I'm referring to?
Yes, I'm aware. I will tell you just, Oxy already reached a voluntary agreement with them. So you'll see on the pooling, only Coterra is listed as the pooled party. So we provided notice to that party, but since we sent out that notice, Oxy already was able to reach voluntary agreement with them. So we did the notice, just not necessary at this point.
Yeah, let me look at your second case real fast before we actually.
It should be the same thing there. They reached voluntary agreement with that same party.
It's only the two persons, and then also they reached on Pomera on this one as well.
That's correct.
That's correct. Okay.
Oh, I'm already jumping the gun onto my next case. Sorry.
And you'll be able to provide this email to us by end of day. Is that correct?
Absolutely. Yes.
Mr. Hearing Examiner, I don't have any further questions for this case. And
Perfect. Okay, Ms. Vance, please file a cover letter with that supplemental exhibit, and we'll take these two cases under advisement as long as we get that by 5 o'clock.
You got it. Thank you.
Thank you. Okay, Mr. McClure, thank you for an excellent and productive morning. Let's move on to Mr. Fordyce and his first case in Spur Energy Partners. There's two cases, but I'm going to call them separately, it looks like. 25979.
Mr. Examiner, Dana Hardy on behalf of Spur Energy Partners, and there are no other appearances.
Ms. Hardy, do you want to do both together or separate?
I will do them separate.
Go right ahead.
Thank you. In this case, Spur seeks an order pooling uncommitted interest in the Yeso formation from approximately 2,500 to 4,000 feet TVD, underlying a 320-acre, more or less, standard horizontal unit comprised of the north half of Section 23, Township 18 South, Range 26 East in Eddy County. Spur will dedicate the unit to the Margaret 23 fee wells. Our exhibits include the land testimony and exhibits of Drew Oldis, who has previously testified as an expert in land matters before the division, and the geology testimony and exhibits of Matthew Van Wee, who has also previously testified before the division and been recognized as an expert in petroleum geology. Our notice information is included in Exhibit C. We did timely provide notice to all affected parties by certified mail on February 12th, 2026. And we did timely publish on February 17th, 2026. So with that, unless there are questions, I request that the exhibits be admitted and that the case be taken under advisement. Thank you.
All right, thank you, Ms. Hardy. Exhibits admitted without exception. Would you please call your landman?
Yes, Mr. Oldis, can you please turn on your video?
I hear him.
All right, sir, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Would you spell your name?
Drew, D-R-E-W, Oldis, O-L-D-I-S.
And you've been previously qualified by this division?
Yes, sir.
In what field?
Petroleum landman.
Mr. Fordyce?
Good morning, Mr. Oldis. If I could first direct your attention to the compulsory pooling application checklist on page 3. In the AFE, CAPEX, and operating cost section, the monthly supervision rates are listed as 10,000, 1,000?
Yes, that's under our JOA.
And now if we could turn to page 6 in your statement, paragraph 14, it lists those rates as 10,000, or excuse me, 8,800. So one of these needs to be corrected. Is that a fair statement?
Yes, sir.
Now, if we could turn to page 23, that's Exhibit A3. I'm looking first at Tract 4. Are there no pooled parties in Tract 4? Because it seems that there's some parties in 3 that are being pooled that also exist in 4 that are not being shown as pooled. Are there pooled parties in Tract 4?
No, sir. There is 2 separate different JOAs that Track 4 is under a separate or another contract with only SCP, Permian, and Exama that have the working interest, and the overrides allowed to be pooled in their granting language.
So no pooled parties in Tract 4.
That's correct.
And just below that, there's another Tract 4 that's 5
Yes,
acres.
sir. Yes, sir. Oh,
Is
sorry, that
that
should be
the
track
track?
5. That should be updated to be track 5.
Okay, very well. So there's 2 corrections, I guess, one in your statement and one here in Exhibit A3. And I don't have any other questions for this witness.
All right. So Mr. Fordyce, if that completes your questions of the witnesses, Miss Hardy, how long
I
would it
have
take?
questions for the geologist. I'm sorry, Mr. Hearing
Thank
Examiner.
you.
I don't have any more questions for this witness. I have one question for the geologist.
Thank you. Didn't know that. Can you call your geologist?
Yes, Mr. Van Wee, can you please turn on your video?
Can you hear me?
Yes.
Would you please raise your right hand, please? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Would you spell your name?
Matthew, Matthew, Van Wee, VAN space WIE.
Thank you. And you've been previously admitted as an expert before this division?
Yes, sir.
In what field?
Petroleum geology.
Thank you. Mr. Fordyce?
Good morning, Mr. Van Wee. If you could direct your attention to Exhibit B3, which is on page 49 of the exhibits.
Yes, sir.
So we're looking at the cross section, and I'm curious about the depth severance, which is discussed in the exhibits, but it's not necessarily clearly defined anywhere. If I asked you to show or add that depth severance on this cross section, would you be able to do that?
Yes, sir. It basically is equivalent to the tub top there, but I will be happy to amend Exhibit B3 to reflect that in the exhibit.
Okay, very well. I have no further questions for this witness.
All right. So would you recap for Ms. Hardy what we need before we can take this case under advisement?
Yes, Mr. Hearing Examiner. In the land exhibits, I believe Mr. Oldest said that on page 6, number 14, where his supervision rates were 8,800, that was incorrect. And that on Exhibit A3, the second tract 4 was mislabeled. It should be tract 5. And on Exhibit B3, if we could add to that cross section just something showing us where that depth severance occurs.
Ms. Hardy?
Understood, and I think we can get those to you today.
Would you confirm with your witnesses now so that we know for sure whether we can leave this record open?
Sure. Mr. Oldest and Mr. Van Wee, can we provide those amended exhibits today?
Yes.
Okay. All right. So Ms. Hardy will leave the record open till 5 p.m. today, and then we'll take it under advisement. If we don't get it by 5 p.m., please file a continuance.
Understood. Thank you.
All right. Thank you. We're off the record in that case. Let's go on to the second Spur Energy Partners 25983.
Dana Hardy on behalf of Spur, and there are no other parties.
Perfect. Go right ahead.
Thank you. Spur seeks an order pooling uncommitted interest in the Yeso formation underlying a 320-acre standard horizontal spacing unit comprised of the south half of Section 10, Township 19 South, Range 25 East in Eddy County, and will dedicate the unit to the Polo AOP Federal Comm Wells. Our exhibits include the land testimony and exhibits of Scott Hartman, who has previously testified and been recognized as an expert in petroleum land matters, and the geology testimony and exhibits of Matthew Van Wee, who has obviously previously testified and been recognized as an expert. And our notice information is included in Exhibit C. We did timely provide notice to all affected parties by certified mail on March 3rd, 2026, and provided notice by publication on March 7th, 2026. So with that, I would ask that the exhibits be admitted and that the case be taken under advisement.
Exhibits admitted without exception. Mr. Fordyce, I know you have found an error in A6. Is that something you can discuss directly with Ms. Hardy, or do you need a witness?
I could pose the question to Ms. Hardy, and if she doesn't know the answer, we'll get the Langman. So, Ms. Hardy, I'm looking at Exhibit A6 on page 42, the ownership commitment exhibit. And I'm looking specifically at line 3, the entry is trustee of the Joanne Civilly Rupert Trust, and they are listed as committed, but the commitment type is NA. So I'm assuming that they are committed. If they are committed, we need to just correct that to show what type of commitment, I guess.
Yes, and I thought you might ask that question. And they are committed under a JOA. So we could go ahead and submit a corrected version of this that says JOA instead of NA.
Perfect. I have no other questions for this case.
Ms. Hardy, how long will that take?
We can do that today.
All right, I have 5 p.m. and we'll take under advisement. All right, we're off the record in that case. Thank you. Let's move on to 25984, Devon Energy.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Derek Savage with Aberdeen and Shield appearing on behalf of applicant, Devon Energy Production Company, LP, and I believe there are no other parties who have made an entry of appearance.
Go right ahead.
Case 25984 covers lands in sections 22 and 15, Township 20 South, Range 30 East, Eddy County, New Mexico. The landman, Daniel Brunsman, has testified previously before the division, and his credentials have been accepted as an expert in petroleum land matters. The geologist, Tom Perriam, has testified previously before the division as an expert witness, and his credentials have been accepted as a matter of record. In this case, Devon seeks orders pooling all uncommitted interest in the Bone Spring Formation, designated as an oil pool, underlying a non-standard 1280-acre, more or less, spacing units comprised of sections 22 and 15. The units will be dedicated to the Tiger King 22-15 FedCom wells. Orientation of the wells is stand-up, south to north, and the location of the wells is standard. Devon is applying for administrative approval of the non-standard spacing unit. Mr. Brunsman's Exhibit A includes his landman self-affirmed statement, C-102s, and ownership breakdown, well proposal letter with AFEs and the chronology of contacts. And Mr. Forsyth, I do have to point out that Colgate, as a record title owner, is listed in the ownership, the record title owner to be pooled. However, for some reason, they slipped through the mailing list. So we are going to remove Colgate from the list to be pooled. And now they're a record title owner, so they know no working interest, and they are non-participatory. We typically will pool record title owners because sometimes it's convenient regarding federal units when it comes to the ratifying the communitization agreement. But it's not necessary that they be pooled, and we'll take care of that with the BLM. Mr. Perryman's Exhibit B includes his self-affirmed geology statement, along with the 5 geology exhibits showing the potential for development of the unit as described in his statement. Exhibit C provides a self-affirmed statement of notice for mailings and publication notice. Notice was timely mailed on March 3rd, 2026, and timely published on March 7th, 2026. Mr. Hearing Examiner, at this time, I move that exhibits A, B, and C and all sub-exhibits be admitted into the record for this case and that the case be taken under advisement. Counsel and witnesses are available for questions. Thank you.
Exhibits are admitted without exception. Mr. Fordyce, who do you have questions for?
I have my first question for Mr. Savage. And actually looking at your compulsory pooling application checklist on page 12, it seems to be missing two complete sections. The AFE CAPEX and operating cost section and the notice of hearing section. And since those weren't supplied, obviously they weren't reviewed.
Okay. Can we add those and get those to you and update the compulsory pooling checklist as an amended hearing packet?
If you get it by the end of the day, yes, I'd be fine with that.
Okay. Is this something that has been added recently? Or is this something that has been standard for a while? I thought we had used the current compulsory pooling checklist for this.
The copy I have downloaded in my archives is dated as of, and I believe this is the latest copy, April 24th of 24.
Okay.
2024. So
okay.
To my knowledge, there hasn't been an amendment to that. I don't know why those two sections are missing.
Yeah, I'm not sure either, but we'll certainly take care of that.
Okay, I had no other questions for this case.
Okay, so Mr. Fordyce, from your perspective, what's being submitted and when are we taking it under advisement?
There's two sections missing from the checklist that needs to be revised. And also, Mr. Savage said that he was going to be removing Colgate as record title owner from pooling.
So if he gets these in by 5 o'clock, there's no further review on those sections of the checklist?
Well, since I didn't review them, it would probably be better to continue this case so that I can double check not only the checklist, but the issue with Colgate.
Okay. So, Mr. Savage, can we turn off other people's microphones, please, Miss Chance?
This is Jackie McLean. I'm trying to speak. Can you hear me?
I can hear you, yeah, but I was in the middle of a sentence, so can you wait just one moment?
Yes.
So, Mr. Savage, this case needs to come back around for further review. So, we can try to expedite it for you. What I understand is the next docket this would be applicable to, and I'm still hearing interference from the back, which is going to wreck our AI transcript. Is it possible to mute any microphones, please, if you're not speaking? So, Mr. Savage, I think the 21st of April would be the next docket we could put this on. Does that work for you?
Yeah, that would work. And I guess so the April 15th, that's
right. We can't do it on that docket, right?
Can't do it on that docket. Okay, yes. And April 21st would be acceptable on that.
So you'll continue this case to April 21st after you submit the information, and you don't have to submit it today, obviously. You're not
thank you.
Yeah. Ms. McLean, did you have something on this case?
Yes, I do. Jackie McLean on behalf of Colgate, and Colgate would like to waive notice on this case, and that they can proceed forward with, as they already have the case being pulled.
Thank you, Ms. McLean. We didn't have a record of your entry.
No, we did not enter an appearance in this case, but I've just heard from the landman at Permian Resources / Colgate, and they are waiving notice.
Perfect. Thank you, Mr. Van.
Thank you.
Mr. Herring, would that alter the review on this? If we, that would leave the amendment of the CPAC, and if, I don't know if that could alter the
Mr.
timeframe.
Fordyce has indicated that he wants to review the information that's missing on the CPAC.
Okay.
All right.
Thank you.
Okay. We're off the record in this case. Let's move on to Avant Operating 25986.
Good morning, Mr. Hearing Examiner. Dina Bennett on behalf of Avant Operating 2.
Thank you.
And although not noted on the worksheet, MRC Permian Company has entered an appearance in this case.
Thank you.
Yes, good morning still, Mr. Hearing Examiner, Mr. Fordyce Pollivance with the, on behalf of MRC Permian, and we're just preserving rights.
Perfect. Thank you, Ms. Vance. Go right ahead, Ms. Bennett.
Thank you. Case 25986 is a companion case to two cases that were previously heard by the division, cases 25747 and 25748. In this case, Avant is seeking approval of a non-standard spacing unit and compulsory pooling for a unit that's in the west half of sections 10, 15, and 22. And originally Avant had included these what had been considered Wolfcamp wells in a application that involved upper and lower Wolfcamp wells. And at the February 5th hearing where the original case was originally heard, Mr. McClure indicated that the lower wells were actually upper Penn wells and requested that Avant dismiss those wells from the application and refile. And so this application is the refiled application that includes only the upper Penn Wildcat wells. And as a result, well, during the conversation with Mr. McClure at the last hearing, I asked if these would be considered oil wells. He indicated that that was an open question, but Avant thinks these will be oil wells. So for the moment, anyway, I've included the building blocks for oil wells, understanding that there may be further discussions with the division that needs to occur after the wells are drilled. And also, I wasn't clear about whether there was a pool code for these wells. I don't think there is. And so for that reason, I left the pool code off of the C102s and the CPAC. So that's just a bit of background. I've included the usual suite of exhibits, including self-affirmed declaration of Tiffany Sarantinos, who's previously testified before the division, and her credentials have been accepted as a matter of record. Same with Mr. Harper, the geologist for Avant Operating 2. He's previously testified and his credentials have been accepted. And I included my self-affirmed statement that shows that notice was timely mailed and timely published, with mailing occurring on February 23rd and publication on March 3rd. So with that, I would ask that the exhibits be admitted into the record and the case be taken under advisement.
Thank you. The exhibits are admitted without exception. Mr. Fordyce?
Yes, Mr. Hearing Examiner, I have questions for the layman and the geologist, but first I might have a moment with Ms. Bennett here to reply to some of what she was just saying. So first of all, the division has created a pool code for this acreage. And it's one of those lengthy Wildcat pool codes. If you're ready to write it down, we could try that.
If you want to just give me the pool code number, I can look up the actual pool code, the name of the pool.
Okay, that would be good. 98410.
Okay, thank you.
And it's and again, it's one of these WC025, bunch of numbers and letters, Cisco-Canyon 98410. Now this pool was set up originally as an oil pool, but without any gas oil ratio information. That is subject to potentially change. Just so you're aware of that. One other maybe slight correction there on page 3 of the compulsory pooling application checklist. Kind of a typographical error in the section where for the spacing unit and standard horizontal well spacing, it says, the reply is yes. But I believe there actually is. Yeah,
Yes.
so it should be
Well,
no.
so yes, I did. I did mean to put no. I did mean to put N, that it's a non-standard.
Since it's being corrected anyway, maybe we'll just fix that part.
I will. And just to clarify, in terms of the pool and the pool code, I can, cutting to the chase here, I can make those corrections today on the C102s and on the CPAC.
Yeah, first I have some questions for the landman and geologist.
Sure. And so Tiffany Sarantinos is the landman. And as I mentioned, she's previously testified and her credentials have been accepted as a matter of record.
And what about the geologist?
Same with the geologist, John Harper.
Can we get them both? Are you gonna have questions for both, Mr. Fordyce?
Yes, Mr. Examiner.
Let's get them both sworn in at the same time. Can we stop sharing?
Sure, let me, yep.
Okay, there we go. Would you both please raise your right hands? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Harper, I didn't hear you
Yes.
say yes. There we go.
Yes, sorry.
Since I'm speaking with you, Mr. Harper, would you spell your name?
John Harper, John, last name Harper, Harper.
Okay, and for the record, you've been previously qualified as what expert?
Sorry, an expert in petroleum geoscience, geologist.
Perfect, thank you. Wait, did you say petroleum geology or did you say petroleum geoscience?
I said both, but geology, sorry.
Thank you very much. Okay, and now, Ms. Sarantinos, would you please spell your name?
Yes, it's Tiffany. Last name is Sarantinos, Sarantinos.
All right, thank you. And you've previously been qualified as an expert in what field?
Petroleum land management.
Perfect. Go right ahead, Mr. Fordyce. Who do you want to question first?
Ms. Sarantinos, looking at, if I could direct your attention to Exhibit A4 on page 24. In this summary of working interests, it indicates that Earthstone, Permian, and Reed and Stevens are committed by a JOA.
Correct.
But then if we turn to Exhibit A8 on page 50, there's a little bit of a discrepancy. They're still shown as uncommitted, I believe. So one of these exhibits appears to need to be updated or corrected.
Dina, could you go back to the other one?
When you say the other one, can you say what exhibit number and page it is?
A4. Yeah, she got it. Thank you.
Well, it's for the record. That's why I'm asking.
Okay. Yep. A4. Thank you. Yeah, I do believe we have them under JOA, and I think we did catch that on the last one too, Dina. If you remember, perhaps.
Yes, I can fix that on this, in the updates, if that's acceptable to the division.
Yes.
Can I also direct your attention, Ms. Sarantinos, to Exhibit A9 on page 53? This is a summary of the non-standard unit notice. So your table on the right, it says Wolfcamp NSU notice list. And now we're basically changing this to a different pool name and code and formation. Would the notice list be the same for the upper Penn pool as it is what you're displaying on this exhibit?
Yes, that's correct. There is no change of interest between the two. This was just originally filed with the original packet, and since there was no change, I think that's why we stuck with this one.
Okay. I have no more questions for Ms. Sarantinos. I have a question for the geologist. Mr. Harper?
Yes.
On Exhibit B2 on page 60, my question to you now is, since we've identified these proposed wells in the Cisco Canyon, would you be able to indicate on this exhibit where the top of the Pennsylvania system is?
Yeah, it seems to be a hot topic. And I do agree.
Yeah.
It's